Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hello and welcome to Hull on Estates. You're listening to episode number 646. I'm Stuart Clark.
And I am Tsvetomira Niklin.
Hi, Mira. Good to chat with you today.
Likewise, I look forward to this podcast with you.
I think this is our first podcast together, so very excited to be here with you, virtually today.
Likewise.
So we have an interesting kind of case to talk about. It's a couple of years old, but it kind of touches on a couple, we'll call them intersectionalities of, estate trust litigation regarding incapable litigants. And the case is called Huang versus Braga. It's a 2020 case of the Court of Appeal. 2020 ONCA 645 is the citation. We'll make sure it's up on the on our post as well with this podcast. But it's kind of an interesting intersectionality, as I said, of incapable litigants, of someone who, in the context of litigation, had a litigation guardian appointed for them because they were found to be incapable of representing themselves in the proceeding. That litigation guardian was the public guardian trustee. They then settled the case, got that settlement approved on behalf of the incapable litigant, and then the incapable litigant wasn't happy with the whole situation and tried to challenge the whole structure. But maybe we'll take a step back for a second, and Mira, if you can kind of give us kind of a very basic, background of the facts on this file.
Sure, Stuart. My pleasure to do that. This case is actually an incapable involved in an accident. So it's not particularly an estates litigation case, but the rules do transfer over with respect to litigation guardians. So in this case, Ms. Huang was in an accident around the year 2000, and where she sustained injuries. However, there wasn't anything to point out at the time that she was incapable. Her injuries weren't entirely related, her incapability wasn't entirely related to the injuries she sustained in the accident. So shortly after the accident, Ms. Huang started a couple of proceedings as an individually represented litigant. She didn't have counsel for some of them. She did also retain counsel at some point, but I believe she had something to the effect of 5 or 6 different lawyers representing her. During the course of litigation around the year 2016, the judge became a little bit concerned with her capacity issues and ordered a capacity assessment. Subject to that assessment, Ms. Huang was actually incapable, and one of the reasons major depressive episodes, which were affecting her ability to reason with respect to settlements. There were a couple of settlements on the table, which the judge became concerned why she wasn't accepting them. So subsequent to her finding of being incapable, in 2016, the PGT was appointed as a litigation guardian to Ms. Huang. And after that, the PGT kind of took over all management of the proceedings. They appointed a separate new counsel, and with the help of that new counsel, they reached a settlement with the defendants. That settlement was put before the court in 2020 under Rule 7.08 of the Rules of Civil Procedure, which requires that when there is a precedent under disability and is represented by a litigation guardian, that the court must approve that settlement. The court did agree to the settlement. It was a settlement to the effect of $1 million, and effectively it was approved. Then we move on to a little bit in the future, and Ms. Huang decided that even though she was represented by a litigation guardian, she wasn't satisfied with her settlement, and she sought leave from the court for appeal. And this is when this matter was heard before the Court of Appeal of Ontario. One interesting thing to note is that these proceedings obviously continued for a very long time. And in 2019, there was an order under Rule 37.16, which actually prohibited Ms. Huang from bringing any motions without leave of the court. So the court, at the Court of Appeal, did consider whether she stood any merit to bringing an appeal for the settlement approval, but they found that the reasons she brought forth were not sufficient. They weren't very good at all, actually, and her appeal was dismissed.
Thank you for that, Mira. Yeah, so as Mira kind of touched upon there, this case is, complicated into actually an accident, car accident case, which is, not really estate litigation related, but for our purpose, it offers a great kind of walkthrough by the Court of Appeal of Rule 7, right? So Rule 7, broadly speaking, is the rule that we use when we have an incapable party to a proceeding. And in this instance, you think incapable, this person was themselves, mentally incapable due to probably the car accident or something else, age, whatever it was. But that term also applies to people who are under 18, right? So this rule, which you have to use if you have a party who's under a disability, includes people who are, 16 years old, and also people who are 90-year-old who have dementia. It's basically how you would wrap them in this litigation and make sure that they're both proper parties to the proceeding. And then also, once you have a settlement, as happened in this instance, that settlement is then also binding on them when they can't themselves sign that settlement. So broadly speaking, when you have someone under a disability and they're involved in litigation, you need to appoint what's called a litigation guardian to represent them in that proceeding. And the rules have a long list of what you have to do. There's an affidavit that has to be sworn by the person who wants to be appointed. But broadly speaking, it's done under Rule 7.01 of the Rules of Civil Procedure. And it basically says that, look, if there's someone who's to a proceeding who's incapable, whether because they're a minor or because of some other reason, you need to have a litigation guardian represent them. And once the litigation guardian represents them, for all intents and purposes, that litigation guardian is that person. They are the incapable person proceeding. They represent them. They, give instructions to counsel. They can enter into settlements on behalf of the incapable person. They can go all the way to trial and be the person at trial who's leading or defending this proceeding on behalf of the incapable person. In this instance, that's exactly what happened. This person, it appears, started their own proceeding, and then some way along the line, someone said, wait a second, I'm not sure this person is capable of representing themselves anymore. I think they need a litigation guardian. The court obviously weighed the evidence, looked at what evidence was led regarding this person's capacity, said, yep, I agree, they do need a litigation guardian, and appointed the government office, the public guardian and trustee, the PGT, to be their representative, the litigation guardian. Within that, then, within Rule 7, once you have a litigation guardian appointed, if a settlement is reached, the litigation guardian, in theory, can say, yep, I think that's a great settlement, but they don't actually have the authority to sign and bind the party. Only the court has that authority under Rule 7.08. So that's what happened here. Basically, the litigation guardian entered into settlement saying, yep, I think this is a great settlement. They then, under Rule 7.8, went to court and said, court, I think this is a good settlement. Will you approve this settlement on behalf of the incapable person? The court here said, yep, I think this is a good settlement. They approved it. At that point, basically the court steps into the shoes of the incapable person and signs the settlement on their behalf, which is what happened here. All normally pretty boring stuff that happens in the context of a incapable litigant. But here, interestingly, and as Mira mentioned before, well, the person who was found incapable didn't like the settlement and didn't think they were incapable and wanted to keep fighting and challenging and appealing both, the order approving the settlement, also just generally the work that the litigation guardian was doing on their behalf. And interestingly here, the court rightly says, look, once you have a litigation guardian appointed, your standing as an individual litigant stops. You're now incapable. You can't make separate submissions or take separate positions from your litigation guardian. Your litigation guardian is you. And if your litigation guardian says to do X, that is you saying to do X. You're no longer a separate person, which I think is interesting.
I agree. I actually found it, just hearing about this case to begin with, I was like, wow, that sounds terrible that the court and someone else is taking away so much autonomy from a person that is incapable. And I thought to myself, hey, maybe they should get some sort of a say. But in reading this case, it actually makes sense. I see the reasoning behind why sometimes we take authority from people and how important it is to actually protect protect them from themselves, essentially.
Yeah, and you can see the chaos they're trying to prevent, right? I mean, in this instance, we have a court that's both found someone's incapable enough to need a litigation guardian. So they've already said, yep, I agree. This person needs someone to represent them in this proceeding. Then let the litigation go for a while. A settlement was reached, which in accordance with Rule 7.8 was then approved by a judge on behalf of the incapable person. And then to have the incapable person after the fact say, wait a second, no, I'm going to try to overturn all this and keep this going. I mean, there's chaos that can happen if there's two different positions being taken by the same person, in effect, right? The litigation guardian is the incapable person. And if they're saying, I think this, and then the actual person saying, no, I think this instead, I mean, the court can't reconcile those two. So they say, no, once you are incapable, and once you have a litigation guardian on your behalf, you don't get a say anymore in the actual proceeding. The litigation guardian is the only one who does. Now, I suppose in theory, someone could then bring a claim against the litigation guardian themselves if they thought that they were doing a bad job or were negligent or could, did something improper. But in this instance, I mean, we have a court who's reviewed the settlement and has said, yep, I agree. Rule 7.8 says basically that the court can't approve that settlement unless the court thinks it's in the best interest of the party on whose behalf the providing consent, the incapable person. It doesn't matter if everyone else in the world thinks it's a great settlement. The court has to say, I am the incapable person. Is this a good settlement for me as if I was that person? And here the court said, yep, I think it was. Proved it. It's now binding on that person. I mean, I'm not sure how a litigation guardian could do more under that circumstance than, follow all the rules we're supposed to. But obviously, I mean, the fact that the person was found incapable probably, helps explain why maybe some of these issues that we're seeing at the side kind of bubbled up, right? So, I mean, this person obviously had some unhappiness of what was happening with their case, but, the court process was followed, settlement was approved, and the Court of Appeal, I think quite rightly, dismissed the appeal brought by the incapable person saying, no, you can't do this.
Well, then there's also the issue that in reading some commentary about this case, I found a very interesting comment that capacity does vary sometimes. So while at a certain point in time, a person can be found incapable, very unlikely in the future, if there's a separate assessment and, circumstances can change, this can be revisited, and this doesn't seem to have been the case in this matter. So that just speaks to the fact that, she was persistently incapable. And another point to look at is that this accident effectively happened in the year 2000, which was some 20 years ago. So there's a certain question as to how long proceedings should go, and how much court resources we can allocate to one person. So even if there is some arguments to granting leave on appeal, I feel like it's a good choice to kind of restrict that to a certain point, especially in light that she brought so many motions and there was so many things involved in this action over the years, that at a certain point you just kind of have to say, like, it is what it is, and here are the facts, and take it.
No, it's a great point, Mira. And you're right. There are options available, and capacity can ebb and flow with time. And I think the rules contemplate just that situation, right? The rules allow, so if a litigation guardian has been appointed for someone while they're incapable, and then later on they believe, what, I'm no longer incapable. I think I can represent myself. The challenge would be to the litigation guardian appointment, right? You'd say, well, I'm going to now try to reappoint myself to represent myself in this proceeding. I no longer need a litigation guardian. But while that litigation guardian is still in place, it's basically a court finding that you can't represent yourself here. You're no longer the person to talk to for this proceeding. If you think it should be you need to challenge their appointment. But as long as they're there, I can only listen to that person. So that's kind of interesting. Same with guardianships, right? Guardianship, you have a guardianship appointed, but if you think, hey, you know what, I've now gotten to the point that I'm now capable, I no longer need a guardian, there's recourse within the statute to apply to the court to remove that guardianship, at which point you, in theory, would regain your capacity, for lack of a better word. But it's a very interesting case. It kind of, as I said, offers a great intersectionality between, incapacity law and Rule 7 and how it plays within civil litigation. And it kind of helps you think through some of these issues. So if anyone's ever needs a kind of a thought exercise of, well, what is the court doing when they're appointing litigation guardians and they're approving settlements on behalf, this case offers an excellent kind of run through of the role of the court and the litigation guardian and the incapable in the whole situation. But yeah,
definitely very good food for thought. I found that extremely interesting, and it was quite educational as well. And it's really nice to see the reasoning of the court. And like I said, to me at first it was a little bit shocking. I was like, oh my gosh, what do you mean? Like, this person's not happy with their settlement, but it does make sense when you read the decision why.
No, exactly. But yeah, so we'll make sure the citation is up on our website. But otherwise, I think that brings our podcast to a close. Thank you, Mira. It's been great to podcast with you today.
And thank you, Stuart.
And if anyone has any comments, please leave us an email or send us a comment on our blog. Thank you very much.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.